Good afternoon and welcome to this event. My name is Rosa Celorio and I serve as Associate Dean for International and Comparative Legal Studies at GW Law School. I welcome you to the 12th Annual Live from EL event, which will be focusing this year on the issue of climate change. It is wonderful to be able to welcome all of you to this event organized via Zoom. It is really a true honor for GW Law School to host and be part of this event every year. I'm also very grateful to the Office of Legal Advisor of the State Department, the ABA section of International Law, and the American Society of International Law for their collaboration, co-sponsoring, organization, and presentation of this event. I also share a special thank you to the ABA section of International Law for facilitating us the Zoom platform that we are using for the event this year. A special thanks and recognition as well to Ren Betauer for conceptualizing and coordinating this very important yearly event of dialogue and reflection on international law. We're very privileged to be able to work with him at the International Comparative Law Program at GW Law School. Questions from online viewers can be submitted via the question and answer function later on after our speakers offer remarks. And we all very much look forward to hearing insight on the role of attorneys at the State Department Office of Legal Advisor in addressing climate change issues and their connection to international law. As most in attendance know, there has been a significant surge in attention to climate change concerns due to their magnitude, widespread nature, national and global scope. There are treaties and sources of international law, which will be discussed today, providing a roadmap to states on how to address climate change challenges, including adaptation, mitigation, and resilience measures, and the incorporation of this issue in national policies and strategies. Without further ado, I would like to introduce Richard Bisek, who currently serves as acting legal advisor at the Department of State. Mr. Bisek joined the Office of the Legal Advisor in 1999 and became a Deputy Legal Advisor in 2011 and the Principal Deputy Legal Advisor in 2006. He previously served as the Assistant Legal Advisor for European and Eurasian Affairs and as the Assistant Legal Advisor for Employment Law. Prior to being promoted into the Senior Executive Service, he served in EL offices advising on issues related to law enforcement and intelligence, appropriations, and legislation. And before joining the Office of the Legal Advisor, Mr. Bisek worked at the U.S. Department of Justice and at the law firm of Hogan and Hartson in Washington, D.C. He received his BA from Stanford University, his JD from Georgetown University, and his LLM from Cambridge University. It is truly an honor to have you here and the rest of the panelists at this event today, and I'm very grateful for our continued collaboration. We will now have remarks from Richard Bisek.
Thank you, Rosa. Can you hear me? If you could just give me a thumbs up, good. Many thanks to you for hosting this discussion and to our co-sponsors, the American Society of International Law, the ABA International Law section, and of course, George Washington University Law School. Our special thanks once again to the ABA for providing the platform for hosting Live from EL over Zoom for the second year in a row. I hope that conditions will allow the speakers and audience members of next year's Live from EL to perhaps sit in a room together. In the meantime, we're very grateful for the renewed opportunity to hold this event and connect with a worldwide audience virtually. As much of our audience is already aware, the Office of the Legal Advisor, succinctly and affectionately known as EL, serves as the General Counsel's Office of the Department of State. In that capacity, our over 250 attorneys have the great privilege of providing guidance to policymakers working to address the foreign policy challenges facing the United States and the world. Some of these challenges are quite specific to the United States or a small group of countries. Others are global challenges that affect every country and that no one country can solve. Nothing exemplifies a challenge on a global scale more than climate change. It is global in three fundamental ways: its causes, its impacts, and the actions taken to address it. The global nature of the causes are well known. Greenhouse gas emissions that cause climate change come from all corners of the globe and all sectors of the economy. from the energy we use to power our houses and workplaces to our land use practices and much more. We are also seeing today the global nature of the impacts of climate change, as well as the scale of the potential consequences if this challenge is not addressed. These impacts affect our lives as well as the lives of countless individuals around the world. There are environmental impacts, such as warming temperatures and changing weather patterns. There are economic impacts, not only in fields particularly dependent on the environment, such as agriculture and fishing, but many other areas of trade and economic activity. There are also social impacts on food security, on unemployment, on access to housing, and on migration. And there are security impacts, as the impacts of climate change can exacerbate the drivers of conflict and lead to greater instability. And finally, action to address climate change can only be successful if it is global. Because no one country is able to address the causes or effects of climate change on its own, coordinated action on climate is the focus of intense attention among governments and civil society around the world. And as many of you know, President Biden has made addressing climate change a top priority of his administration, both domestically and in our foreign affairs. This is reflected, among other things, in his appointment of John Kerry as Special Presidential Envoy for Climate, leading a team at the State Department to work with Secretary Blinken and other State Department colleagues to make addressing the climate crisis central to our foreign policy. Elle plays an important role in these efforts. Given the global nature of the challenge posed by climate change, it is unsurprising that it comes up in the work of our office in many different ways. We can expect that this trend will continue as the scope of climate change and climate action continues to grow. As our speakers today will elaborate, policymakers have looked to law and international institutions as a tool in their efforts to organize and advance global action on climate. And climate change and its impacts have begun more and more to intersect with other fields of law, including fields that developed decades before the challenge of climate change was understood. Our speakers today will talk about some of the different issues that Elle is working on related to climate change. Well, we certainly could fill many hours on this topic. We hope that over the next hour and a half, we can give you some sense of the role and the role that Elle plays and the roles that we as lawyers play in the field. And I'm joined today by an incredible group of speakers, and I will introduce them briefly before turning over the floor. Katie Ewell-Page is the Assistant Legal Advisor who heads the Office of the Legal Advisor's Office of Oceans and International Environmental and Scientific Affairs, or LOES, as we call it. And it provides advice on international environmental law, among other issues. Andy Neustetter is our lead climate attorney, and he is in LOES. Nathan Nagy is another attorney advisor in LOES who advises on law of the sea issues, including as relates to the issue of sea level rise. And just to prove that it isn't only LOES that works in this space, finally, but not least, Anna Melamud is an attorney advisor in ELL's Office of Human Rights and Refugees, or LHRR, where she advises, among other things, on legal issues related to migration. So with that, I want to repeat my thanks to all of our sponsors and co-sponsors, and particularly to you, Rosa, and I would like to turn it over to Katie.
Okay, well, good afternoon, everyone. Thank you, Rich, for that introduction. And thank you all for joining. It really almost 200 participants. That really is wonderful for us to be able to share some of the work that we're doing on behalf of the US government. As Rich said, I am the Assistant Legal Advisor in charge of LOES, and the attorneys in our office really are the core legal advisors for all types of environmental agreements that the US is seeking to negotiate and continue these days. Over the last few years, I've been in this job about 5 or 6 years now, we have seen increased attention in the legal space to climate change issues, just as there has been growing awareness of the need to address climate change on the policy side. And I'm really pleased that we're able to bring together this array of attorneys today to just give fellow attorneys out there a sense of what it's like to try to tackle legal issues that affect climate change. LOES has been very closely involved in the negotiation of the UNFCCC framework from the very beginning. And we've had the privilege through a number of lawyers who have rotated through the office through the years to really be in the room when we're drafting the language that forms the core obligations of these agreements. Andy Neustetter, as Rich said, is our lead climate lawyer, and he has been in our office for about 5 years now. And he is really, I would say, the leading expert on the Paris Agreement and all of the obligations and all of the work that has gone into creating the Paris Rule Book, which in some ways, I will say, was even harder than the Paris Agreement to conclude, because when the Paris Agreement was concluded in 2015, there were a number of issues that were kicked down the road. They were considered too hard to resolve at the time. And they were kicked down the road, and Andy had to come in and come up with the language that would really bring effect to the Paris Agreement and make implementation meaningful. Nathan Nagy is going to give us a concept of some of the difficult legal issues in the law of the sea space, and the very important issue of sea level rise, and as countries grapple with their changing maritime boundaries. And Anna Melamud, I think, will be a great addition to the conversation as she talks about the impact of climate change on people and migration. So I really am going to turn it over to the panelists. We're going to try to leave some time at the end. I think we're going to try to leave 20 minutes at the end to field questions from you all. We're really interested to hear what you have to say. And I thank you for participating, and I'll turn it over to Andy. Thank you.
Thank you, Katie, and Rich and Rosa for those introductions, and thanks to GW and the ABA for hosting this event. Very happy to participate. So I'll plan to cover a few things. As Rich said, you know, I in particular could go on for hours about all of this. I'll try not to do that, but I'm going to give, to start with an overview as briefly as I can of the legal architecture of the international climate regime under the UN Framework Convention on Climate and the Paris Agreement. Then I'll talk about some recent developments under Paris, particularly in the last year, and how sort of we see the Paris Agreement in action now that we're past 5 years after its adoption. And then just a brief look at the landscape outside of the Paris Agreement and some of the different fora that are addressing climate in different ways. So to start with the climate negotiations regime, the primary forum in which we've engaged on climate for the last 30 years really is the UN Framework Convention on Climate Change and its annual conferences of the parties. Actually, exactly 30 years. The UNFCCC was adopted in 1992. I think the 30-year anniversary is coming up in May. And it entered into force in 1994. The US has been a party from the start. The UNFCCC includes an objective, which is to achieve stabilization of greenhouse gas concentrations in the atmosphere at a level that would prevent dangerous anthropogenic interference with the climate system. The agreement contains various obligations related to both mitigating and adapting to climate change, as well as providing finance for developing countries. This includes some obligations related to reporting of greenhouse gas emissions and actions to address climate change, some general obligations to reduce emissions, and it included a non-binding aim for parties who are listed in what's called Annex 1, which was essentially the OECD countries as of 1992. So there's an aim for those countries by 2000 to reduce their emissions to 1990 levels. And then, as I mentioned, there's also obligations on finance and various other things. But in addition to establishing these kind of core obligations, the convention was designed as a framework. It's right there in the title, with the expectation that it would create a venue for a multilateral process for cooperation to address climate change going forward. So it establishes various subsidiary bodies, establishes a conference of the parties to meet every year. And so we've been meeting since 1994 annually, with the only actual year that we missed was 2020 due to the pandemic. The convention also contemplated the possibility of negotiating additional protocols or related agreements, and there have been a number of developments over the years in that space. So the first one, which I'll touch on only quite briefly, for which negotiations started almost immediately after entry into force of the convention, was the 1997 Kyoto Protocol. Just to highlight a few key features, the Kyoto Protocol, the main thing it did was establish binding emissions reduction targets. These were through 2012 initially. There was later an amendment that added targets through 2020. The targets were internationally negotiated, and by that I mean they were sort of inscribed in the protocol itself as individual targets for each country. But the targets only applied to those Annex 1 parties. There were no new obligations for the developing countries. The agreement was adopted in 1997, but ultimately it didn't work for the United States to join. And I think especially the notion that there would be these binding obligations for the United States and other developed countries, but nothing at all analogous for other major emitters, was just not really viable for the US to join. So the Clinton administration had negotiated it, but didn't submit it for advice and consent. And then George W. Bush administration said more definitively that the United States would join. So the Kyoto Protocol, sort of in part by design, due to its coverage only of those Annex 1 parties, and especially then without the US involved, it covered only a smaller and smaller amount of global emissions. And in any event, it only included those targets through 2012 and then 2020. So there was a recognition there would need to be a post-Kyoto framework, and that to really address the problem, you'd need all the major economies in that framework, the US, China, India, et cetera. And so the result, after a lot of twists and turns and bumps in the road, was the 2015 Paris Agreement. As Katie said, the Office of the Legal Advisor was very closely involved in sort of designing the architecture of the Paris Agreement, and at a big picture level, and also at a small picture level of, the specific word in all the articles of the Paris Agreement. To just describe the key features of the Paris Agreement, it establishes long-term goals on the three kind of pillars of the agreement, which are mitigation, adaptation, and finance. So on mitigation, it establishes a long-term temperature goal of holding the temperature increase to well below 2 degrees below pre-industrial levels, and pursuing efforts to limit temperature rise to 1.5 degrees. It includes an adaptation goal to enhance adaptive capacity, and a finance goal to make finance flows consistent with a pathway towards low emissions development. So with respect to mitigation, the basic building block of the agreement is what's called the Nationally Determined Contribution, or NDC. And in a lot of ways, the Paris Agreement kind of took the opposite approach of the Kyoto Protocol. So with the NDCs, the emissions reduction targets are nationally determined. They're not internationally negotiated. These targets are required to be submitted by all parties. It's not just the Annex 1 parties. The annexes would disappear in the Paris Agreement. And the targets are non-binding. Also, the targets have to be submitted every 5 years, with the expectation that each successive target is more ambitious than the last. So rather than agreement with an end date, you have something that's intended to be durable over a longer period of time. The agreement also includes a transparency framework, a robust transparency framework for reporting emissions and tracking progress towards targets. Each party submits reports every 2 years, and especially in the context of sort of the non-binding targets, this was seen as critically important that you have this robust transparency system, so all parties can see what other parties are doing, that they're sort of achieving their targets, or if they're not on track, so that there can be pressure to sort of move the system together. And the last piece of sort of the system set up on mitigation is there's a global stock take every 5 years to look at collective progress. So altogether, this scheme of regularly submitted targets, strong transparency, and collective review of progress is what some people call the Paris ambition cycle, or some people call it the quote unquote ratchet mechanism. And from a legal perspective, what's interesting about the Paris Agreement is that you see an interesting mix of binding and non-binding provisions in the agreement. So the binding obligations are, or at least the core ones, are largely procedural obligations. So the obligation to submit an NDC or to submit your reports and to submit various other pieces of information. But the content of the targets is non-binding. So tying back to Kyoto and the UNFCCC, we've seen thus a kind of evolution in the regime over the years with different legal forms. And I think part of this is a struggle of parties through all this to find trade-offs between different aspects. So bindingness on the one hand, stringency or ambition on the other hand, durability, and then also the inclusiveness to get as much of a global scope as you can. One other note, since we're talking about L's role, the Paris Agreement also includes an implementation and compliance committee. So this is something that's relatively common for multilateral environment agreements, and LOES is very often involved with compliance committees, both with negotiating their terms of reference, also participating as members of compliance committees. So I'm just recently elected to be on the Paris Committee, and I have some colleagues who are on other compliance committees. So that kind of brings us to, that's what the Paris Agreement is. To bring us up to present day, the Paris Agreement was adopted in 2015, entered into force in 2016. And as I'm sure everyone knows, under the Trump administration, the United States announced it intended to withdraw. That withdrawal did officially become effective in accordance with the terms of the agreement on November 4th, 2020. In the meantime, what was happening in the multilateral space was, and Katie alluded to this, was the negotiations over the so-called Paris Rulebook, which is a set of guidance and procedure documents that are critical for implementation of various aspects of the Paris Agreement. So most of these were adopted in 2018. This was dozens and dozens of pages of decision text on technical but important topics. And though the US had announced the intent to withdraw, we were still a party, and so we still did engage actively. LOES was very closely involved in all of that. Katie and I shuffled off to a lot of negotiations for the rule book. One element where L led in particular, mentioned before, the compliance committee. So we led on developing the modalities and procedures for that committee. After the completion of the rule book in 2018, the next kind of big moment was supposed to be 2020, which is when parties were expected to submit their NDCs. So this was really the first test of how this ambition cycle would work, and whether the legal form and sort of the compromise of the agreement would actually deliver increased ambition towards achievement of the goals. However, COVID kind of got in the way of that. So the 2020 COP was postponed, and because of COVID complications, also a lot of countries had trouble submitting updated NDCs in 2020. So what that actually meant was that when President Biden was inaugurated and we rejoined the Paris Agreement on the first day, rather than sort of the new administration coming in right after a big moment or the big COP in Glasgow, the new administration came in the midst of sort of the preparation for the big COP, which was held in November 2021. I'll talk now a little bit about sort of what the biggest developments are that we saw in Glasgow and how the regime is looking going forward. So I think in the run up to Glasgow, the US objectives included, first, that we wanted to, with the NDCs in particular, but through other initiatives, to leave Glasgow a lot more on track to keep a 1.5 degree limit to temperature rise within reach. Second, I think recognizing that we wouldn't be able to sort of simply close all the gaps, come out with a full commitment from parties to continue strengthening their ambition and their actions in this decade in particular. And third, that we would secure outcomes on the outstanding elements of the rule book. There, as I said, there were a few tricky things that didn't get completed in 2018, particularly related to carbon markets. Was a very challenging one. So those elements were still on the table for negotiation. And you saw throughout last year a lot of efforts from the president, from Special Presidential Envoy Kerry, from Secretary Blinken, from a lot of other senior officials and cabinet officials, sort of in pursuit of those objectives. So how did we come out on all those? And how does that reflect on sort of how the Paris system is working is the big question. So with respect to the objective of leaving more on track to keeping 1.5 within reach, I think we did see a lot of substantial progress, enhanced NDCs by many parties, including the US. The US submitted an updated or a new NDC in April of last year to reduce emissions 50 to 52% below 2005 levels in 2030. We also saw, in addition to the NDCs, action happening at a lot of different levels and through a lot of different initiatives. And I think for lawyers, this is interesting because it's not all just happening through sort of implementation of the Paris. There's lots of different forms of cooperation that take place, both through non-binding initiatives, actions, and other international fora that all kind of can contribute to towards the goals of the Paris Agreement. So we saw leader level commitments, including a substantial sort of political declaration on forest and land use about ending deforestation by 2030 that a lot of countries joined at a leader level. We saw announcement of various initiatives. The US and the EU led one called the Global Methane Pledge. This is a non-binding initiative, but it's basically a pledge by countries, and there's over 100 and still growing now, to reduce global methane emissions 30% by 2030. And then you also saw various commitments from the private sector, from civil society. Another feature of the Paris Agreement is that it was intended through these COPs and through engagement with different stakeholders to not just be parties, but to have different stakeholders be able to contribute, which is needed. So that was, I think all of those things added up to being substantially more on track towards keeping 1.5 within reach. But obviously there's a recognition that more needs to be done. And so the parties did adopt various decisions, including one sort of the cover decision, I call it, which is called the Glasgow Climate Pact. This is a consensus decision, and it reflects the need to accelerate action during this decade in various different ways, calls for additional efforts on mitigation, adaptation, finance. And then finally, we did conclude all of the outstanding elements of the rule book. We and Elle were very interested in that. I'm happy if there are questions about any of that. I'm more than happy to answer them. In particular, the as I said before, the carbon markets decisions were quite challenging, but we got a good outcome on those. So that brings us to Glasgow, and the question is, what is next? How do we go forward? I think we've heard Secretary Kerry refer to this year and Secretary Blinken as a year of what they're calling implementation plus. So that means that the need for implementing existing goals and commitments, and this is the national NDCs and things like that. Also, all of those different types of initiatives that I mentioned before, as well as initiatives that happen in other fora. But as the Glasgow Climate Pact makes clear, and as the president and John Kerry have emphasized, we are still behind, and we need more than just implementation of the existing goals. And so that's where the kind of plus comes in. So, for example, there's a continued effort, and this is reflected in the Glasgow Climate Pact, for countries that haven't yet submitted NDCs aligned with that temperature goal to do so this year. So you'll see a lot of diplomatic effort on that front. So with all of these things, some of these are carried forward through the sort of negotiating agenda under the Paris Agreement and the UNFCCC. Some of them happen outside the negotiation and in other fora. So that leads me to my last piece, which is to touch briefly on a little bit of the landscape outside of Paris. And Elle is involved in a lot of these different fora as well, and advising on sort of what are ways that we can use different fora or different areas of law to advance climate objectives. And so I'll give just a few examples. So first, there are some sectors where we have emissions, that substantial emissions that aren't happening within a particular country and that thus aren't really addressed in NDCs. So specifically, I'm talking about international aviation and shipping, where the emissions are coming outside of national borders. So there's efforts in the sort of two specialized agencies that deal with these sectors on climate. So one is the International Maritime Organization for shipping. We in LOES work with our clients very closely on regulations that the IMO has developed and continues to develop on reducing emissions from international shipping. There's a lot of activity going on there this year to develop medium-term and longer-term measures to reduce shipping from emissions from shipping. The second is the International Civil Aviation Organization, or ICAO, based in Montreal. And for the last over a decade, the ICAO has been considering climate measures. One big thing it did in 2016 was adopt something called the Carbon Offsetting Reductions for International Aviation, or CORSIA. This is a scheme that calls for carbon neutral growth from international aviation beyond 2020, and it requires offsetting of emissions by airlines above a certain baseline. This year in particular will actually be a big year for ICAO because the ICAO Assembly meets only every 3 years, and this is one of those years. And so there will be review of CORSIA and a look at sort of how is it doing and contributing to the towards the global climate effort. And there's also going to be discussions about possibly setting a long-term goal for emissions of international aviation. Another example of places where climate is coming up are different fora that address international security. So a primary one is the UN Security Council. There's been a lot happening at the Security Council, or a lot of discussion at least happening in the Security Council about climate change. There's various experts groups. There was, I guess it was the end of last year, there was a resolution that was proposed on climate change. The US supported it and sort of actively engaged with the other members of the Security Council. That resolution was vetoed, but you continue to see a lot of effort in the Security Council by the US and other partners to try to address the impacts of climate change in the context of peacekeeping operations and other aspects of the Security Council's work. You also see discussions in NATO, in the OSCE. Again, I could go on, but these are just a few examples. And then we also see climate issues increasingly intersecting with other areas of international law. So a couple of examples that we won't get into in detail just because we don't have time, but our trade law. So this includes questions currently about carbon border adjustment. The EU has proposed a carbon border adjustment, which is basically kind of a tax on products coming into the EU that have a higher carbon intensity. That's a very reductive description of it. And if we have trade experts, I'm sure people will quibble with that description, but that raises a lot of questions. If they're how can that be done consistent with WTO obligations related to non-discrimination, and how does that fit within environmental exceptions under the GATT, et cetera. We also see climate change come up in different ways in human rights law, how climate change affects the enjoyment of human rights, how when parties take action to address climate change, how they can respect their obligations on human rights. One example in that space is that sort of in the, critical minerals are very important for addressing climate change. And there are, various reports of human rights abuses and in the context of critical mineral mining and supply chains, et cetera. So you see all of these kinds of intersections. And then finally, two areas, and I'll leave it to my colleagues here, where we are seeing a lot of intersection is law of the sea and migration. And so I'll turn it over to, I think, Nathan first on the law of the sea aspects. I guess the one thing I'll just say for students who are watching this, you see with the big landscape, if you want to work on climate change and international law issues or international issues, it's not, maybe 15 years ago, the UNFCCC was sort of the main place. But nowadays, there are just so many different organizations that are working on the international aspects of climate change, international organizations, different US government agencies that are working on different international aspects. So there really are, because it needs to be this kind of all of society effort that Rich described, there are lots of different places where you can go as a lawyer to work on different aspects of addressing the climate crisis. And I guess over to Nathan.
Thanks, Andy. Yeah, so first of all, thanks to everyone who's tuning in. It's really heartening to see such a large amount of interest in these issues. So as Andy mentioned, I work on law of the sea issues in LOES, and one of those issues that I work on is sea level rise. So in order to explain exactly how the sea level rise issue comes up, I think first I'll need to just give a little bit of basic law of the sea information, things like, what is a maritime zone? Why are maritime zones important to countries? And after that, I'll sort of explain how sea level rise is interacting with that legal regime in a way that is creating a lot of problems and a lot of concern for a lot of countries around the globe. Then I'll finish up by talking about some solutions that have, or potential solutions that have been raised, some of the pitfalls with those solutions, some of the recent developments in the areas, in particular, some legal theories and proposals that have been put forward in the last year or so. And finally, I'll chat a little bit about the challenges that some of those recent developments have posed from a practice perspective. So to start out, basic law of the sea. The rules regarding a country's maritime claims and maritime zones are reflected in the 1982 Convention on the Law of the Sea, which is also called UNCLOS. It's important to note that the US isn't a party to UNCLOS, but we do view many of the substantive provisions, including those regarding baselines and maritime zones, as reflecting customary international law. So we view them as being binding on all countries, including the US, sort of regardless of whether or not they're treaty signatories. The sort of core concept in this area is that land dominates water. There's no country in the world that has a freestanding claim to any ocean area. It's the relationship to their sovereign land territory that's the legal underpinning of a maritime claim. And so once you've established that, you need a system of relating your maritime claims to your land claims. And UNCLOS does that by setting up a system of baselines and maritime zones. So start off with, what are baselines? Baselines are the points on a map that distinguish your land territory from the water. What's called a normal baseline, and this is the baseline we're going to be talking about mostly today, is defined in Article 5 of UNCLOS as the low water line along the coast. In other words, where the land is at low tide on your coast. I'll just point out that there are rules for drawing different types of baselines other than the normal baseline, but they tend to apply primarily in special circumstances. So you can draw straight baselines without having to go along those low water points at every point in the line. You can draw those if you have a deeply indented coast or fringing islands. Archipelagic countries are allowed to draw something called archipelagic baselines. There are cases where you can draw straight lines to close off your maritime claims, or sorry, your baselines in a bay. In these other situations, the rules can get pretty complicated, but the important thing for the purposes of this discussion is that in each case, they represent a system for relating the underlying geography to your legal entitlements. That being said, for today, we'll talk mostly about our normal baseline. And the key with the normal baseline is that if you go landward from the normal baseline, you have your land territory. And if you go seaward from the normal baseline, you have your maritime zones. So what are maritime zones? Maritime zones are areas where states have different rights, privileges, and responsibilities. And maritime zones are all related to and measured from baselines. So the maritime zone that's closest to the baseline is called the territorial sea. It goes up to 12 nautical miles out, and states have sovereignty in their territorial sea. It's a reflection of the sovereignty that they have on land. They can do things like enforce their criminal laws there and that sort of thing. Beyond the territorial sea, you have something called the exclusive economic zone. And the exclusive economic zone extends up to 200 nautical miles out from the baseline. This is where states have sovereign rights and jurisdiction with respect to natural resources in the water column. So sovereign rights and jurisdiction is something less than full sovereignty. It basically refers to the exclusive right that countries have to manage and exploit those natural resources. And when we're talking about those natural resources in the water column, typically that means fish in like 80% of the cases, but it can also be relevant to other things like wind power generation, genetic resources in the water column, and stuff like that. And then the last maritime zone that's relevant to this conversation is called the continental shelf. The continental shelf goes at least 200 nautical miles out from the baseline, but can go further. There's a sort of system of rules that defines exactly how you can draw your outer limits for your continental shelf. The important thing there is that they're not necessarily related to a specific distance from the baseline. But when you're talking about rights that are granted in the continental shelf, it's similar to the exclusive economic zone. You're not talking about full sovereignty. You're only talking about management and exploitation rights related to natural resources. And it covers things like hydrocarbon deposits, mineral deposits, and any other resources that are found sort of on or below the ocean surface. So how does the normal baseline work? Obviously, you can draw your baseline with reference to those low water points that I mentioned, but over time, those points geographically can change. And we refer to this in the law of the sea context with the phrase that the normal baseline is ambulatory. So whenever there's new land that's naturally created, for example, if there's volcanic activity that creates an island, or land that is naturally destroyed, so think of a barrier island being submerged after a hurricane, this actually changes where the baseline is. And the concept of the ambulatory baseline was present in customary international law predating UNCLOS. And it's also reflected in the US's own practice. So the National Oceanic and Atmospheric Administration has a practice of publicizing nautical charts that describe where the US's maritime zones are. An interagency committee actually has to perform a legal and geographic review for any significant changes that impact the drawing of those maritime zones on the US coastline on a regular basis. So this is something that we've been doing for decades before UNCLOS was even negotiated. It's worth noting when you're talking about baselines and maritime zones that there's a mechanism in UNCLOS for depositing current charts and coordinates with your baselines in them with the UN Secretary General. But the key point that I want to point out for now is that using this mechanism doesn't actually preclude updating those things. So, if you're an island nation and you have, a volcano forms a new island that you claim, sovereignty over, you can update those deposits, even if you've already done them, by claiming that area and sort of claiming the relevant maritime zones around them. So now let's talk about the particular challenges that sea level rise poses in light of this existing legal regime. Baselines are ambulatory, and so sea rise works legally on baselines and their corresponding maritime zones in the same way that any other natural change in the geographic makeup of your coastline would change them. If sea level rise moves a country's baselines inward, there's going to be a corresponding change in your territorial sea and exclusive economic zone at the limits. So 200 miles out, if you lose a certain amount of land, you're going to see an indentation in the outer edge of your maritime zones. This is an issue for all countries. It's especially significant for island countries. They tend to rely more heavily upon natural resources in their maritime zones than other countries. They have a higher risk of losing land territory to sea level rise. And when they do, the corresponding diminishment in the maritime zone is proportionally a much larger impact than it is for larger or non-island countries. So, in a worst case scenario, you could have an island ends up being completely submerged. That could mean losing sovereign rights in your exclusive economic zone in a 200-mile radius, which is a huge amount of area and access to resources that you're losing out of. So a lot of countries see this as an existential issue. Their maritime zones are just that important, both economically and culturally, to the way that they exist in the world. So you have this regime that sets up baselines in maritime zones, and you have sea level rise presenting this problem. One of the ways you would initially think that you could fix it would be just to change the legal regime, which is easier said than done. And the sort of most straightforward way to do that in a treaty regime is just to amend the treaty. However, UNCLOS is going to be very difficult to amend. It's a multilateral treaty. You'd need to achieve consensus in whatever changes you wanted to make, which presents an opportunity for rent seeking for countries who might agree with changes to how baselines are drawn, but also have their own pet issues that they would want to sort of achieve if the entire treaty were opened up for amendment in a new convention. So I think most countries in the world don't see actually amending the treaty as a reasonable way to move forward. There has been a lot of work done in solidifying maritime zones through the conclusion of maritime boundary agreements, though. So in any place where your potential claims to maritime zones overlap, and this can happen essentially anytime there's one country's baselines that are within 400 nautical miles of another country, so that their exclusive economic zones have a potential area of overlap. The exact delimitation of that boundary has to be determined either by the agreement of the parties, or sometimes if there is an arbitration by a court or a tribunal. Typically, these treaties or arbitral decisions don't actually make any reference to baselines in the actual delimitation that they set out. It's literally just a set of coordinates. It's A to B to C, and it doesn't have any particular reference point to the land. And this makes sense because it's not useful to have a maritime boundary treaty that can shift based on circumstance. You don't want to have to go back to the negotiating table because your coastline moves. So once set, these coordinates can stay in place regardless of coastal changes, and a lot of countries are focusing on concluding maritime boundary delimitation agreements as a way to solidify their maritime zones. This does have a couple of drawbacks. Technically, the treaties and decisions only apply to the signatories and parties to those treaties or those decisions. But those are the countries that would actually be involved or be likely to be involved in a dispute almost all of the time. You need a very unusual fact pattern to arise for the US to have a vessel that was contesting, like an Australia-New Zealand maritime boundary. But the other issue with sort of delimiting these things through maritime boundary agreements is that the approach just doesn't work in a case where your exclusive economic zone borders the high seas. If there's not another country on the other side, there's no one to conclude a treaty with that would sort of set those outer limits. in the last year, in August of 21, or 2021 to be specific, there was an interesting development in this space internationally when the Pacific Island Forum, which is a group of Pacific Island countries, released something called the Declaration on Preserving Maritime Zones in the Face of Climate Change-Related Sea Level Rise. And it's worth noting that the Alliance of Small Island States, which is an organization that has a lot of overlap but is slightly different in character, put out a similar statement not long after that. This declaration noted that UNCLOS doesn't impose an affirmative obligation to keep baselines and outer limits of maritime zones under review, nor an obligation to update charts or lists of geographical coordinates once deposited with the UN Secretary General. The countries in the declaration declared that once they have, in accordance with the convention, established and notified their maritime zones to the Secretary General of the UN, that they intended to maintain those zones without reduction, notwithstanding climate change, sea level rise. And they finally concluded by proclaiming the rights and entitlements that flow from maritime zones so established and notified shall continue to apply without reduction. So functionally, these countries made the argument that this UNCLOS provision on deposit of your maritime zones, on publication and notice to other countries, would functionally supersede the provisions that govern baselines. So, once you had properly established your baselines and notified them to the UN, you basically, in the argument of these countries, now get to no longer pay attention to the provisions governing how baselines change over time. So from a practice perspective, this does present a pretty difficult challenge for US lawyers to navigate in the context of our international diplomacy. The US has made clear in statements in international fora, including statements before the UN General Assembly's Sixth Committee, that the United States recognizes that rising sea levels are a very real threat, and we're committed to working with others to promote our common goal of protecting maritime zones from challenge and doing so in a manner that we can all support as consistent with international law. So there's a policy imperative for the United States to address this issue. It's not something that we're sort of interested in letting lie. However, we also have to make clear that our position has been for decades that coastal baselines are generally ambulatory. And just as a quick aside here, as a matter of global policy, it's really important for the United States to adhere to a clear rules-based framework for resolving maritime legal issues. For example, we just published a study examining in detail China's expansive maritime claims, including their attempts to enclose vast areas of the South China Sea and what they argue should be straight baselines. This isn't really that relevant to this topic, but it's important just in the sense that we need to recognize that the urgency of the problems posed by sea level rise, but at the same time, we have to be cognizant that an ill-considered legal solution could have follow-on effects that impact our high seas freedoms and the resolution of maritime disputes all around the world. So in the case of the Pacific Island Forum Declaration, it's been very important to be clear with foreign governments sort of what we can and can't agree with. Parts of the PIF argument are actually accurate in our view. So for example, we do agree that UNCLOS doesn't actually have language that imposes an affirmative obligation to update your deposits regarding maritime zones. This practice of depositing maritime zone information is actually really useful in a number of contexts related to the law of the sea, and it's one that the US wholeheartedly supports. But we also have to simultaneously make clear when we don't agree with a legal conclusion. So there's nothing in US practice or interpretive experience that lends support to the idea that these deposits with the UN have the legal effect of sort of locking in your rights and entitlements, notwithstanding the provisions that deal with the behavior of the normal baseline. And so we have some difficult conversations where we have to make clear to other countries that we sort of like part of what they're doing. It makes sense. It makes sense from a sort of practical standpoint to get these deposits in, but that the legal effect of the continued legal rights and entitlements isn't one that we would necessarily agree with. So these kinds of discussions can be very difficult, but ultimately they do help our foreign partners understand exactly where US efforts on the issue of sea level rise can best complement the efforts that they're making. And with that, I think I'm running over my time, so I will turn it over to Anna.
Great, thank you, Nathan, and thank you, everyone. Thank you, GW. Working on migration issues for LHR, L's Office for Human Rights and Refugees. I think I spend far smaller amount of my time on climate issues than my colleagues in LOES. But we have had some interesting work in this space over the past year, supporting clients on issues at the intersection of climate and migration. And I'll describe some of that work today. To frame the policy landscape a little bit, at this point, it's pretty well established that the movement of persons is something that's significantly impacted by climate change. And this was recognized as early as 2010 in the decision of the Conference of Parties to the UNFCCC, which emphasized 3 types of human movement in the context of climate change. There is displacement, often forced, migration as compared to displacement considered voluntary, and then planned relocation. So we know that this kind of movement is most often internal within a state, but can also be across international borders. It can be the result of both slower onset events like sea level rise, but also sudden onset events fueled by the impacts of climate change, like natural disasters, storms, wildfires. Climate change is also most commonly among several reasons for displacement or migration, not usually the sole factor that compels a person to flee their home or influences their decision to move abroad. So these analyses of reasons can be quite difficult. But ultimately, as the climate crisis has become more urgent, there's been a growing recognition among NGOs, UN agencies, scholars that these issues merit serious attention, and by the Biden administration as well, which brings us, to our recent work on these issues. On February 9th, 2021, within weeks of taking office, President Biden issued an executive order calling for a US interagency report on climate change and its impact on migration, including forced migration, internal displacement, and planned relocation. This report, which is publicly available, was a whole of government effort led by the NSC. It was published in October and marks the first time that the US government is officially reporting on this link between climate change and migration. So the report's divided into 4 sections: international security implications, protection and resettlement considerations, foreign assistance, and multilateral engagement. And you can imagine all the different agencies of the US government that fed into all these different pieces. But my office, LHR, worked with clients in the Bureau of Population, Refugees, and Migration, PRM, and colleagues across the interagency on the protection and resettlement section. We also participated in a series of consultations with various external stakeholders, IOs, civil society organizations, academics, and others that substantially contributed to the content of the report. So today I'd like to discuss the legal framework we sketched out in the report, specifically for the cross-border movements in the climate change context, including under refugee law, international human rights law, including a recent treaty body decision on this issue, and then certain other complementary domestic law provisions. I'll also mention some of the protection-related recommendations that the administration endorsed in the report, which if implemented could help fill some gaps in protection and potentially give rise to some new legal pathways under US law. So turning to legal frameworks, I'll start by acknowledging that these instruments to protect displaced individuals in the context of climate change are rather limited in scope. Starting with international refugee law, we often hear the idea of climate refugees, but really that's a bit of a misnomer. Displacement as a result of climate change is not itself a basis for international protection under the key instrument in the space, which is the 1951 Refugee Convention and its 67 protocol. And there are a lot of reasons why persons displaced by climate-related effects might not meet this definition, but a key issue is nexus. Under the refugee definition in the 51 Convention, an individual facing a risk of persecution needs to be on account of a protected characteristic, such as race, religion, nationality, membership in a particular social group or political opinion. And normally the harm caused by climate change doesn't have a motive, let alone one linked to a protected characteristics. But there are limited circumstances, which we recognize in the report, in which the existing refugee definition can interact with climate events in a way that could give rise to protection. For example, a government may withhold or deny relief from the impacts of climate change or a natural disaster to specific individuals who share a protected characteristic to a degree and in a manner and amounting to persecution. Also, climate activists or environmental defenders could be persecuted on the basis of their political opinion for speaking out against government inaction on climate change. Also, there could be situations involving an interplay between conflict and violence and the adverse effects of climate change. For example, climate change could exacerbate resource scarcity, fueling violence, particularly against populations that are already vulnerable. And that could give rise to a situation where you have persecution on a protected basis. And additionally, climate factors could impact the reasonableness of internal relocation when you have somebody who has a valid refugee claim, but whether they could move elsewhere in the state to avoid persecution could be affected by climate factors. So beyond the 1951 Refugee Convention, the report also discusses some regional frameworks that are not applicable to the US, but which might provide broader protection where they do apply. For example, the Cartagena Declaration is a non-binding framework endorsed by many countries in Latin America, and it includes a definition of refugee to include people who have fled their country because their lives, security, or freedom has been threatened by circumstances seriously disturbing public order. So a much broader definition, no nexus element. Similarly, the OAU Refugee Convention has a similar expansive definition of refugee that includes someone who is compelled to leave their country owing to events seriously disturbing public order. So based on reporting from UNHCR, these broader regional definitions have been applied to extend protection in situations involving at least the confluence of climate factors with violence or other causes. For example, in the 2010-2011 timeframe, Kenya accepted many Somalis as refugees under the OAU regional definition when they fled famine conditions that were influenced by climate change, but then aggravated by political volatility and conflict that limited access to humanitarian assistance to address the food insecurity issues. So that's the refugee protection framework. Aside from refugee protection, certain human rights bodies, including the Human Rights Committee, which is the treaty body for the International Covenant on Civil and Political Rights, or the ICCPR, as well as the European Court of Human Rights and the Inter-American Court of Human Rights, have identified a prohibition of refoulement or forced return that's implied under certain provisions of international human rights treaties. In particular, the Human Rights Committee has taken the position that states parties to the ICCPR must refrain from removing an individual when there are substantial grounds for believing that there's a real risk of irreparable harm, such as that contemplated by Article 6, which is the right to life provision, and Article 7, the prohibition of torture and cruel, inhuman, and degrading treatment or punishment in the ICCPR. So this concept has been around for a bit, but was applied by the committee more recently for the first time in the climate change context in 2020 in the Tetiota case, giving rise to the first decision by a UN Human Rights Treaty body on a complaint by an individual seeking basically asylum from the effects of climate change. And this landmark decision indicated the committee's support for a more expansive interpretation of what the international legal protection framework might be. So to briefly recount the background of the case, it arose when Mr. Tetiota filed an asylum application in New Zealand based on the effects of climate change and sea level rise in Kiribati. He was deported there with his wife and children. He filed a complaint with the committee arguing that by deporting him, New Zealand had violated his right to life under Article 6 of the ICCPR. And his argument was basically that the rise in sea level and other effects of climate change had rendered Kiribati uninhabitable for its residents. He cited violent disputes occurring as a result of a growing scarcity of habitable land, environmental degradation that made subsistence farming difficult, and a freshwater supply that was dwindling because it was contaminated by salt water. So in addressing the claim, the committee reaffirmed its position that the ICCPR implies a non-refoulement obligation, and this protection may be broader than the scope of the principle of non-refoulement under refugee law. The committee also stated that the effects of environmental degradation could give rise to a violation of an individual's right to life under Article 6 of the ICCPR. So ultimately, the committee found that New Zealand did not violate Mr. Titiota's right to life when they deported him, reasoning that despite the very serious situation in Kiribati, sufficient protection measures such as water rationing, alternative food sources, etc., were put in place to preclude a reasonable foreseeable risk of irreparable harm to his right to life. But the committee also observed that without robust national and international efforts, the effects of climate change in a receiving state may expose individuals to a violation of their rights under Article 6 or 7 of the Convention, thereby triggering the non-refoulement obligations of sending states. So as a representative of EL, it's important that I clarify the US government position on these issues. The United States hasn't recognized the competence of treaty bodies to receive and consider individual communications against the United States under any of the treaties to which we're party. New Zealand is party to the optional protocol to the ICCPR, which sets forth this individual complaint mechanism, but the United States isn't party to that. Also, the United States doesn't consider the committee's interpretations of the treaties to be authoritative interpretations of our treaty obligations. We consider them to be non-binding views. And finally, with respect to this particular decision, the US disagrees with the committee's interpretation of the ICCPR as containing non-refoulement protections. In the US view, that position isn't supported by the plain language of the convention or its negotiating history. And we interpret our obligations on non-refoulement to be those that are provided by Article 33 of the Refugee Convention and Article 3 of the Convention Against Torture. So the HRC's, the committee's interpretation is not one that the US government is likely to accept. And in terms of the implications of the decision, it's not legally binding. And it also appears that the committee, at least for now, is taking a fairly rigorous and narrow view of what qualifies as a reasonable risk of foreseeable harm in the climate change context. But nevertheless, the decision could have far-reaching implications. In particular, the committee's interpretation could be adopted by national and regional courts, opening the possibility that human rights-based non-refoulement protections could be applied by some states, at least in extreme cases, to individuals seeking protection from the effects of climate change. And as a result, it has the potential to substantially broaden available protections over time. So in addition to these international law-based frameworks, I'd like to briefly mention some types of complementary and temporary protection mechanisms that certain states have undertaken that could also assist individuals moving in the climate change context. As recounted in the report, these could include humanitarian visas, various regional cooperation mechanisms, and the extension of some form of temporary protected status to individuals fleeing in the climate change context. And the US is actually among those that includes a form of temporary protected status in its law. Under Section 245 of the INA, DHS can designate a foreign state for TPS, temporarily protecting its nationals from removal due to conditions in that country that prevent the nationals from safely returning. And those conditions could be climate-related events, including environmental disasters or other extraordinary or temporary conditions in the language of the statute. So TPS authority has actually been used extensively by the US government to provide protection to foreign nationals in the aftermath of environmental disasters in their countries. For example, Haitians after the 2010 earthquake, Nicaraguans and Hondurans following the Hurricane Mitch in '98, and nationals of Nepal after the 2015 earthquake. But like the other areas described, protection under TPS has its limits. First, it generally only, protects foreign nationals that are already in the United States when the relevant designation is announced. So when you have persons who are forced to flee because of the disaster or event that prompted the designation, they may very well be excluded from protection. Designation on the basis of environmental disaster under the statute also requires a formal request from the foreign government. And some governments may lack the political will or for other reasons might not make the request. Also, as a temporary status without a clear pathway to permanent status in the US and one linked in temporary conditions, TPS is ill-suited to providing a permanent solution for individuals who are unable to return home because of long-term or permanent impacts of climate change. So for example, it would be hard to call a temporary condition a situation where, the lands of a country has been completely submerged. And finally, TPS is discretionary authority. So even where the statutory conditions for a possible designation are met, DHS can decide whether to exercise it or not for a range of policy reasons. So with this framework in mind, I'll briefly address some of the protection-related recommendations endorsed in the U.S. government report. And in particular, I think the most important recommendation was to make sure that the report was just the beginning of these important discussions within the U.S. government, in that it established a standing interagency policy process on climate change and migration that's intended to coordinate U.S. efforts to mitigate and respond to migration resulting from climate change. So this standing interagency policy committee has begun its work with agencies across the U.S. government considering implementation of the various lines of effort identified in the report. And in particular, with respect to protection and some of the issues I discussed today, the recommendations include assessing how climate change may interact with the criteria for refugee status, so as to maximize the application of that criteria in climate scenarios. Also evaluating whether reforms to the TPS statute could better address protection needs arising from climate-related displacement. And finally, and I think most notably, exploring with Congress and stakeholders the need for additional protection for individuals who can establish that they're fleeing serious, credible threats to their life or physical integrity as a result of climate change. So such a novel pathway for humanitarian protection would require legislation, but if enacted, could be a significant form of complementary protection available under US law for individuals displaced in the climate context. And I'll stop there. Thanks so much.
Thanks to all of you so much for your insightful remarks and your generosity in sharing your insight and wisdom with all of us today, especially in a busy time like this. I actually wanted to begin the discussion part of this event with one question, and it's a two-part question. One of them is related to, I'm very curious, and I think a lot of members of our audience are very curious about lessons learned, that you have derived from all of this work in the area of climate change as ELL attorneys. I mean, you describe, all of this work in the area of providing treaty language and also discussions related to implementation. Anything that you could share with us would be fantastic. And the other part of the question is that we have many students watching, and to many of our students, this is their dream job. This is what they would love to do, especially students that are specializing in international law. So it would be great if you could share with us what you think makes a successful attorney working in ELL.
How about if I answer the second half of that question, and then the lessons learned, I'll leave it to the experts. In terms of when we interview people for ELL positions, I know in the front office, we sort of take as a given that if you, and this is going to sound perhaps borderline arrogant, but if you've made it to the interview stage in ELL, you've already got a resume that suggests you're really, really bright. And so, obviously it's important that you do well in your academics, and you do well in your work environment. But for us, we're very much a team-oriented, relatively flat bureaucratically. So it's the great thing about ELL is you have a lot of people who are willing to work as a team, exercise good judgment, good common sense, and be respectful to their colleagues. And I think that sounds very trite, but it goes a long way. And I'm really proud of the ELL attorneys, because I think over the 20 odd years that I've been working here, it's hard for me to come up with somebody who was a gunner, so to speak. Everybody shares in the success and helps their colleagues out through the failures. So, or the troubles, you know, so, you know, I think you just being a good colleague goes a long way. Obviously, technical competence is really important, and willingness to roll up your sleeves and take on assignments, because we are rotational. Take on assignments that you may not find to be, you know, what you thought you wanted to work on, but take them on with a good spirit and do a great job. And, you know, you'll be rewarded with a wonderful career down the road. So with that, in terms of lessons learned, you know, I'll leave that to Katie and the others, because, you know, Katie certainly has seen some changes in the environmental space. I can just say personally, I have been involved in denying the Keystone Pipeline permit twice, granting it twice, and then denying it a third time. So sometimes you have to be flexible. But I'm going to turn it over to Katie.
Well, thank you so much. I mean, I think, you know, it is in fact a privilege to work for the U.S. government on these issues under any administration. I mean, and I do sincerely believe that. And I think that we have such an important role to play in terms of good governance and really trying to adhere to the rule of law and to the provisions of the agreements that are negotiated. And so I think we just do the best we can, but it really is amazing to be able to spend our working hours working on these issues. I think that maybe with the time we have, maybe about 13 minutes, would you like us to field some of the questions in the chat? Would that be helpful? Or I know that thank you. It sounds like we have a very informed audience, which is wonderful. And I will take, maybe just scrolling through here, maybe the human rights and the environment one. Andy, I know that you were adjacent to some of those discussions that were happening in Geneva. Do you have any reflections on that?
Sure, and maybe just quickly before that, I'm happy to address that. On the lessons learned front, I guess for whatever it's worth, my 2 cents is for negotiations. If you find yourself in this kind of negotiation, first you really need to do your homework and come prepared. And I think this is, you know, where we've been successful. The U.S. government can bring a lot of preparation, and this is something where Elle in particular plays a big role of sort of really understanding the agreements, the past decisions, et cetera, the history. Second is to really understand the positions of other parties and to dig under them. I mean, some of this is obvious, but you'll often, at least in the climate space, you'll often see countries come forward with a position that says like absolutely no to a sort of a very wide field of things. But then if you really dig under that, you might find, okay, there's like actually just this one technical thing that they have a problem with, but they're putting up a shield that's much broader than that. And so if you address that technical thing, you can sometimes sort of unlock the whole thing. And then and for that reason, you really need to talk to everyone. And the last thing is just, I think, looking at the history of the UNFCCC to the Paris Agreement, as I laid out, at least in the environmental space, you really need to kind of try to fit the regime that you're working on to the problem that it's addressing. And you can play with different kinds of legal forms. I think sometimes as lawyers in some countries in particular can be kind of obsessed with like everything needs to be binding. But there are trade-offs for pushing for binding things. Sometimes you might not be able to get countries to join certain binding obligations because of domestic law issues. Or if something is binding in the climate space, for example, you might end up with countries be less willing to be ambitious because, you know, the United States can put out a target that's 50 to 52% below 2005 levels. If we had to put out a binding target, it would be probably a lot more difficult. So those are just a few observations from me. On the question that came about human rights, I think so the United States, we've long recognized that climate change and environmental degradation affect the enjoyment of human rights, and there's been a lot of resolutions in the human rights councils that have reflected that, and also, and this notion is reflected in the the preamble to the Paris Agreement, when taking action to address climate change, that states must abide by their human rights obligations. And there's various different human rights obligations that might be implicated, freedom of association, et cetera. It could be a lot of things depending upon the actions. With respect to the HRC resolution and other discussions related to calls for a right to a healthy environment itself, I think those raise questions of whether there's a specific obligation in international law related to the environment. And this kind of goes to the sources of international law that we look to. So is it treaty law or customary international law? So I won't speak for policy positions, but from the L perspective, when we look at these kinds of questions, not just related to climate change, it's important to objectively look at sort of what international law, the state of international law, whether through treaty or custom, what that provides. And we find there's a lot of areas where there are things that are critically important or even fundamental, but for which there may not be specific human rights obligations. So that's just sort of a general observation related to that question. But it really doesn't mean that we don't see relevance of human rights for climate change in various ways, as I mentioned. Thanks.
Andy, thank you so much. I think we have a question here for Katie and Nathan from Professor Sean Murphy from GW Law School. So I want to read that question. It's actually in light of the Pacific Islands Forum and AOC's declarations, as well as statements made by member states in the Sixth Committee this past fall supporting the approach taken in these declarations, is there an interpretation of the convention by the state parties that is beginning to coalesce around that approach, in which the United States is disabled from participating since it is a non-party?
Nathan, why don't you take that one? I know that this is pretty complicated in terms of the formation of customary international law and really what, kind of this is an interesting question about the intersection between policy interest and really tackling this very difficult problem, and then mirroring that up with the legal structures that we find ourselves with. Nathan?
Yeah. I guess I'd start by saying that the question of what you mean by supporting the approach taken in those declarations is an interesting one. And I think, as Katie indicated, there is sort of a policy / practical element to that and a legal element to that. And the answer can be a little bit different for both depending on what lens you're looking through. So on the sort of policy, sort of practical side, I think, I would even say that in the Sixth Committee context, the United States' own statements were sort of generally supportive of sort of the practical approach of making sure countries, properly deposit a set of coordinates for their baselines and their maritime zones that are established in accordance with the convention. I think the question, though, of whether or not everyone sort of agrees legally with the approach of that declaration is a much more complicated one, because the declaration isn't actually altogether that clear about how they reached the legal conclusions that they reached. And I think that if you talk to 10 different countries about whether or not they agreed with that legal analysis, you get 10 different interpretations of what the legal analysis was, and maybe more than 10 different answers about whether they agreed with it. So in terms of sort of coalescing around an interpretive approach, I don't personally think that we're very close to that yet. And as to the second part of the question, which is about whether or not the United States is disabled from participating as a non-party, as I mentioned before, the United States views the provisions of UNCLOS, especially in baselines and maritime zones, as reflective of customary international law. And that's actually sort of a complicating factor in the treaty analysis to start with, right? So from the United States perspective, even if all the treaty parties sort of agree on an interpretation, we still would say, well, there's still customary international law there, and you still have to abide by customary international law for as long as it remains the relevant customary international law, even if you have a treaty interpretation that's slightly different. So the analysis just gets more complicated from there because you can have sort of the same kinds of considerations that go into the formation of customary international law are considered at times when you're when you're analyzing whether or not a particular interpretation of a treaty has become widely accepted. So to make a very long answer a little bit shorter, no, I don't think that the US is disabled from participating, and I think that we are actually a thought leader in the area of the application of these provisions, even though we view them as customary international law and not as binding treaty commitments that the US has undertaken. And as to how they might change in the future, it's a very difficult question, and I'm not sure that there is any sort of consensus there as of yet.
Thank you so much. We actually have another question from Professor Asinti Vitanash about the connection between climate change and marine biodiversity and the work of Elle in this area. If you could discuss a little bit this question.
Yeah, I can take, this is the BB&J question, or?
Yes. Yes.
Oh, okay. All right. Thank you. Well, as many people may know, the BB&J discussions, the biodiversity beyond national jurisdiction discussions, are scheduled to restart after maybe about a 2.5-year hiatus in March up at the UN. And I think that I've worked on that agreement to some extent, and then I think that climate change comes up maybe in the environmental impact assessment provisions, and maybe it's a consideration in the marine protected areas. And the U.S. is certainly, interested in considering the climate change impacts on BB&J and figuring out what makes sense for that agreement to embrace in terms of obligations or commitments with respect to climate change. So for us, I think that this is actually a little bit, if you hear me hedging, this is a little bit more of a policy question than a legal question. So I'm not in those negotiations currently, so I don't have a full understanding of our policy position, but I know that the administration certainly has a strong commitment to fighting climate change. And then ELL's role, which is what we're talking about today, would be to help craft the language that meets the US policy goals as much as we can. So thank you.
Thank you so much. I have a question from Wes Rist as well, from ASIL. He's asking, given the cross-cutting impact of climate change on various issues, does the role of Elle or even the US government more broadly need to approach the issue in a different way? If you have any thoughts on this.
I can maybe take a stab and then others can add. I mean, I think what we see, and as Rich even alluded to in his introductory remarks, just because it's coming up in so many different places, there's more attention on it, and we're engaging on it in ways that we hadn't in the past. At a sort of policy level, if you saw it, the president did an executive order on January 27th of last year on climate change, both sort of domestic and international, and said, climate change should become really central to our foreign policy, including on national security. And so I think that was really, that's not a legal change per se, but it was a kind of a sea change in the way the US government sort of really amplified the way that climate change is considered across foreign policy. So I think you have seen that change. And then with that, as Rich also said, we also sort of see it in a lot of different areas of Elle work, advising clients, working on different agreements or in different fora.
Thank you, Andy. We have a final question because we unfortunately have run out of time, and it's from Michelle Keith. What can attorneys or ordinary people do to help further treaty obligations, international law, emission targets, and overall objectives to realize progress in the area of climate change from the ELL's office view?
I can take a stab, and then Rich, I don't know if you wanted to say something, but I think I sort of alluded to this a little when I was speaking before. For attorneys, there are lots of ways to work on climate change issues now, either domestically. I mean, there's a whole lot of action that our domestic counterparts are taking within the U.S. government, but also, you know, at state levels, at municipality levels, at, you know, in the private sector. There's just so much activity, and with all of that, there's room for lawyers. I mean, even if you think about sort of offshore wind, there's like lots of very complicated transactions that need to happen and regulatory things that need to happen where there's the need for lawyers to work on those things and to make those processes run. And then sort of on the international level, as I said, there's so many ways that climate change is coming up. There's so many places, whether you're, you know, work in environmental fora or work in, you know, our colleagues at the Treasury Department do a lot of work on climate change in the multilateral development banks and other places. So I think it's sort of, there's countless ways that people can get involved, from sort of very local levels to global levels.
Right, and the core of, the core of the Paris Agreement is the U.S. each party's nationally determined contribution, right? So the U.S. has a very ambitious NDC, which we're hoping to meet, but really it needs to be a whole of society approach to reducing emissions and helping us meet that political commitment to reach our contribution. So I think that it does maybe feel like such a big problem that, you know, what can each individual do, but it really does require a whole of society approach, as we've reiterated. Thank you.
Thank you so much to everyone who has participated in this event today. I think this is the perfect way to end. Thank you so much again to all of our speakers and Richard Bisek and all of you for being here and sharing all of your insight and wisdom with us. I also want to share a special thank you with Robbie Nightingale and also Ron Betauer for making this event possible today. And I also want to thank again the ABA section of International Law and ASIL for co-sponsoring this event, including Lauren Mask, Renette Doplek, Mark Agras, and Wes Rist. And thank you all again for participating today. I send you all a message of health and wellness during 2022, and hopefully we meet again very soon. Thank you all.
Thank you, Rosa. It's been a lot of fun, as always.
Thank you so much. It's wonderful to have you here. And good luck with everything. Continue the good work.
Thank you.
Yeah, thank you.
Bye.